Do you know that a guarantor cannot be held liable for any criminal offense committed by the person that he guaranteed? Yes, and by the provisions of Section 7 of the Administration of Criminal Justice Act, you cannot arrest someone in lieu of another, meaning you cannot arrest someone for an offense committed by another person. A guarantor can only be held liable for civil obligations for the person that he guaranteed. A guarantor can only be held liable for the criminal offense of the person he guaranteed if he participated in the commission of that crime. The fact that you stood as a guarantor for someone does not mean you can be arrested for the offense committed by that person. Crime is personal and it cannot be transferred to the guarantor. So the fact that somebody stood as guarantor for someone else does not mean the guarantor can be arrested. And so, except where the guarantor participated in the commission of that crime, the guarantor cannot be arrested for the offense committed by the person he stood as guarantor for. For instance, in a civil matter, the guarantor can be held liable for the civil obligations of the person he stood as guarantor for. And this can include debt or any other civil matter. But when it comes to a criminal matter, the guarantor cannot be held liable for the offense committed by that person he stood as guarantor for. If you stand as guarantor for someone and it borders on a civil matter, you can be held liable even if that person is not readily available. But in a criminal matter, you cannot hold the guarantor liable for the offense committed by another person. So liability as a guarantor is limited to civil matters. It does not extend to criminal matters except you as a guarantor participated in the commission of that crime. In the absence of the guarantor participating in that crime, the guarantor cannot be held liable for the offense committed by another person. I hope you find this insightful and helpful. Keep watching Law Synopsis. I will see you in our next episode.